We may as well get started. I'm going to talk today about Asia M&A. I'm going to be joined with my colleague Ron Fan in talking about this topic. Just as a quick introduction, I've been based in Hong Kong for 14 years. And Ron's also been based in the region for many years. He's from Shanghai, so we've both worked in this region doing predominantly M&A work for a very long time. Just as a quick overview of what I'll talk about and what Ron will talk about today. We've obviously got a different range of attendees here. Most are obviously legal counsel, but we wanted to try and sort of keep the topics reasonably light, or what I mean by that is I wanted to sort of touch upon political, economic issues and how they impact upon legal trends and impact upon M&A trends. So we're going to go into some legal issues in some detail, but I also wanted to touch upon some of the other factors that influence and affect the M&A trends that are happening in the Asian market. We're going to sort of narrow in and focus particularly on the two of the biggest markets in the region, and that's obviously mainland China, and also Indonesia from the perspective of inbound activity. So we're going to go into those in particular because we think that they're hot spots and sweet spots for activity. And I think all factors are indicating that those markets will remain very strong in terms of regional and global M&A activity. And in terms of discussing these trends and flows in terms of M&A, we then want to discuss how they're impacting upon negotiation of M&A deals, and we also want to discuss how they impact on the usage of Hong Kong as an investment vehicle, as a platform for doing regional M&A. Very keen to have your input. If you've got any comments throughout the talk, equally we had allocated 10 minutes at the end for discussion and questions. So feel free if you've got a question or you want to make a comment or have any thoughts. We want to keep this as open and flexible as possible. So please feel free to participate. Very, very broadly, and I think this is sort of something that everybody knows about already, but we wanted just to touch upon key issues from an outbound, inbound perspective. From an outbound perspective, typically regulatory approval is not an issue, but it's obviously an issue in regards to mainland companies in terms of their outbound acquisition activity. And there's obviously a range of other issues that impact on outbound. In terms of inbound, there's obviously a range of key issues that impact on how deals are done in the region, in Asia. But four in particular are obviously quite crucial. Merger control law has become prevalent throughout the region, except for Hong Kong. So it is a big factor in terms of working out your strategy, in particular if it's a multi-jurisdictional strategy. Equally, corrupt practices law has become very, very significant factor, and that applies whether you're talking about a foreign, non-Asian company doing a deal in the region, or equally Asian companies doing deals elsewhere. Corrupt practices law is far more important than it used to be. It is a factor for mainland companies as well. Obviously, that's a huge issue, a huge situation at the moment in mainland China. It does affect their outbound activities as well. They need to think about how they are, why they're doing the deal, and how it's structured, and make sure it's done properly. It's also, obviously, corrupt practices is obviously a huge issue in terms of being a black flag on terms of doing a DD exercise, doing an M&A deal. It's one of the few issues where you can actually say, well, we'll put it in indemnity and worry about it later. It's something that you need to have properly resolved, and it often is a deal breaker. In terms of regulatory barriers for the region, as a general comment, regulatory barriers have dropped. WTO, obviously over a number of years ago, has reduced those barriers. They still exist, and certain markets are still protected to a significant degree, but there is signs that the barriers are dropping across the region. And in some ways, merger control law has, in some respects, replaced FDI law. So when the government doesn't like a particular acquirer coming into the local market, using merger control law as a way of screening that undesirable purchaser from the market. Now, of course, they need to do that in accordance with their own legal systems and in accordance with the rule of law. They can't just isolate, pick on a particular acquirer, but there is definitely a trend where merger control law is used as more of a public interest mechanism to protect the market from undesirable large acquirers. In terms of corrupt practices law, I thought, yeah, as I said, this is probably the key deal breaker in the deals that we work on. All of these legal regimes are increasingly extraterritorial. Everybody's always known that FCPA has extraterritorial effect, and that anything that a US company does anywhere in the world will be caught by that act. But now we've also got the Bribery Act, which was introduced 2 years ago. So any companies that are from the UK or which have UK operations now have to comply with the Bribery Act. The Bribery Act goes further than the Corrupt Practices Act in some respects, in that it's focused not just on government officials, it affects private corporate activities as well. But we do have potentially more extraterritorial effect in terms of the Chinese laws. So I think increasingly we're going to see China is not just clamping down on corruption at home, we are going to see the Chinese government clamping down on corruption by its own entities in other parts of the world, and that may be as a result of more legal reform, but I think that's the global trend, is that we're going to end up in 5 or 10 years' time with this whole panorama of potential corrupt practices laws that we have to comply with whenever we either do activities or do an acquisition. So you have to work through all these regimes to make sure that your project actually may be compliant with 3 or 4 or more jurisdictions' laws. So that's the way of the future, but it certainly requires planning and thought to make sure that we're doing things properly.
Brett, is the prevention of bribery ordinance in Hong Kong, is that extraterritorial? Or is it?
It does have some extraterritorial provisions, but it is reasonably limited compared to the general scope. Right? Yeah. So its actual scope is very more specific. The aims of bribery and specific unfair payments, things like that. So as I mentioned before, due diligence is not necessarily sufficient. In particular, the FCPA has rules on successor liability. So if you buy a company that has historical malfeasance, then you as the purchaser and director of the new company, of the new owner, still may be potentially exposed. So it's not enough to say I've done brilliant due diligence, I asked lots of questions, I discovered a few problems, but from day one when I buy the company, I'm going to stamp out that practice. That may not be enough. You may actually have to get them to self-report, which could well be a deal breaker. Many companies will say, well, why should I self-report before I close a deal? That's just ridiculous. So that is a big factor. So you need to take these things into account early on, because if you get to these issues at the end of a negotiation or at closing, then it's obviously very hard to pull out at the last minute. And you do get that deal pressure to close the deal, even though there is this potential issue sitting there in the DD report. Very quick analysis between FCPA and Bribery Act. Just as I mentioned, FCPA is very much more focused on public officials. And the reason this stuff is relevant is because it's not just about doing the acquisition, it's about the ongoing conduct. So if you buy into a company that has a history of bad practices, and you've identified these and you've identified that they're non-compliant, it is going to be quite difficult to fix the company. So you need to be aware that, and quite often it's not, people who engage in these practices don't leave a paper trail, or they do it by matter of custom, or they say everybody in the industry does this, everybody gives gratuities or facilitation payments, and that's the normal business practice. So it's very hard to stamp these out when they're in existence. So it's very important to know what laws you'll need to comply with once you own the business, so that you can do a proper due diligence and assess the activities that are currently going on just quickly on the UK, way the UK law works, they actually do have a mechanism that provides a defence where if you have adequate procedures in place, then that can be a defence against prosecution. But it's quite interesting to think about that in an M&A context. What are adequate procedures before you actually buy into a business? Or if you're buying into a business which has improper activities already, I think it could be arguable that adequate procedures mean that you don't buy into a business which is doing things badly. So part of your adequate procedures should be that you do full and adequate due diligence, and your procedures should say, we'll not buy a company that's been engaging in these kinds of practices because it's too risky. So to take advantage of that defence, you're going to have to come up with some analysis on that basis. Otherwise, they're going to potentially say that you haven't had adequate procedures because you bought into a business with some problems. I think saying that you fix it after you buy it is not always a solution. So just sort of a very, very rough chart. I mean, there's obviously a lot of statistics around about trends in M&A activity in the region, both inbound and outbound. The general consensus is that over the first 9 months of this year, that M&A activity is reasonably down compared to 2013, but 2013 was a very strong year. But what we want to sort of go into is a bit more to what extent that has been caused purely by economic or industry or government policy factors, and to what extent it may have been affected by legal factors. Volumes are still very significant, so there's certainly not a massive situation where the volumes have dropped significantly. In particular, China outbound is still very high, China inbound is still very high, so we are still talking about a lot of activity. There are other trends that are interesting to sort of try and analyse. There are trends that say that the deal size is down, that there are a lot more deals under 50 million, so there's a lot less big deals. Does that mean that there are less quality targets that people are looking for? There are a lot more minority type deals. There are more JV type arrangements. Some say that there are also more intra-country deals. So say within China there's a lot more consolidation going on there. Equally, there are some signs that there was a trend of more intra-Asia deals. So Asian companies buying into other Asian companies. But there are signs, because of particular political issues that China is having with many countries in the region, that some intra-group activity is actually, intra-Asia activity is actually diminishing. Just in terms of Asia outbound, as I say, China is still very high. Korea, Japan, all the signs are that people we've spoken with, there's generally a consensus of Korean and Japanese companies pulling out of Asia, or reducing pulling out of China, reducing their China activity. There is signs that Korea and Japan are obviously still very heavily involved in places like Southeast Asia, Vietnam, construction industry and things like that. But China's still obviously the largest player by a long way in terms of outbound activity coming out of Asia, Southeast Asia. There's still relatively very little activity coming out of Southeast Asia, apart from, for example, Singapore or people like Temasek. So China outbound status. There's still lots of room for growth, down 23% compared to 2013. Big factor, corruption crackdown. There is increased accountability. So, Rom and I have met with a lot of big Chinese companies over the past 12 months, and there's still a very strong appetite to do deals, but equally there's a government mandate policy to push these companies to do deals. And in many cases, they've still got the fundamental earnings and the fundamental basis to do deals, but the senior officials, the senior executives are under pressure not to do bad deals, and obviously not to engage in any activities that are potentially corrupt. And we think this has led to a significant drop-off on activity. Chinese companies are being cautious, they're doing more due diligence, they possibly have flipped from where they were before. So 5 or 6 years ago, Chinese companies were rushing in, they were overpaying for assets. They weren't engaging necessarily good advisors. They were doing things fast. They wanted to secure the asset. Now they've gone the other direction. They're actually potentially being overly cautious. And I think what will happen is that there will be a balancing out in the near future, provided that other trends continue, provided obviously that economically those companies are sound and they continue to be successful. There's a lot of pressure on officials and senior executives to perform financially. So they've got to prove that what they're buying into is financially good. They've got to meet the magical figure of 8.5% GDP, so they've got to show that what they're buying will actually generate that. But there's a real conflict between that side of things and still the Chinese government's push to invest in strategic industries, which is still very, very strong. So there's a conflict in terms of Chinese government policy there that has to eventually be alleviated. Fundamentals, as I mentioned, still very strong for a lot of the big Chinese companies. And there's obviously still many that are still very, very active. There's a lot of companies doing a lot of purchasing of assets in Europe in particular, insurance sector, for example. We increasingly think there'll be a lot more private enterprise-led trends. A lot more co-investment, so it's coming from both the banks and from the Chinese government that Chinese buyers need to co-invest. They either go in with sophisticated investors, the old days of Chinese companies going in, buying up a project in its entirety, kicking out the local management, and wondering why it didn't work. That stage is passing, and there's a lot more pressure on Chinese companies to focus on the financials, make sure the local management is locked in, make sure potentially a local partner is involved. So a lot more strategic, synergistic sort of approach to doing deals. Presents big opportunities for Western companies as well to sort of link in with these companies. Just very briefly, notable deals, and these are sort of reflective of the industry trends we've touched on. A lot more synergistic approach. For example, the Shanghai House of Fraser buying a UK brand with a view to selling it back into China. So a lot of the big deals are driven by the fact that the companies want to tap back into the Chinese market or Asian markets, as opposed to just purely buying assets per se. So there's a lot more sort of synergistic type approach. One of the other factors in terms of Chinese companies and their activities, as there's been a loosening, a relaxation of the requirements in regards to the rules for outbound activity. And Ron's going to talk quickly. I'll talk about this in terms of the changes to the NDRC rules earlier this year.
Thanks, Brett. On the 8th of May this year, the Chinese Foreign Investment Regulator National Development Reform Commission, or NDRC, has issued a new directive which basically governs for China's foreign investment projects. That is to facilitate the Chinese enterprise to invest abroad and to streamline approval regime. Actually, in late last year, China issued a circular concerning the catalog of foreign investment projects subject to government approvals. So for projects in countries, in sensitive countries or industries, that is those countries which do not have diplomatic relationship with China, or projects which have a very large scale, such as power mains, power grid, cross-border water project, or large land-scale development project would be subject to government approvals. But in this new directive, NDRC has increased the threshold for approval to $2 billion US. So for any project which exceeds that threshold and to be invested in sensitive countries and sensitive industries, that will subject to State Council's approval. If less than $2 billion, they only need approval from NDRC, even the projects are in the sensitive countries and industries. This sensitive countries and industry concept is quite important. If you are an international target from China's perspective, perhaps you need to think about whether you should transfer or segregate equities assets from those countries and industries if you are very keen to attract Chinese investment. For any projects which between the 300 million to 1 billion, under the new regime, you only require filings or registrations with NDRC. For any projects under 300 million, if your SOEs and State Assets and Supervision and Administration Commission, you need to do the filing. If you are not SOEs and the SASIC, you only need to do filing with the Provincial Development and Reform Commission. As I mentioned, the approval process has been streamlined, and the approval, the powers for approval has been deputized to the provincial NDRC. The focal point of this new approach is to replace a decade-long approval system that require filing for the record or recordation, or in Chinese words, it's called Bei'an, to decentralize the regulators' approval powers for Outbound projects. The next issue I'd like to discuss is the reinvestment by Chinese offshore subsidiaries. There's a misconception that if you are Chinese offshore subsidiaries, if you want to reinvest in overseas, you are subject to the approval from Chinese regulators. In fact, if you do not require guarantees or financial support from your parent company, and you actually do not require the approvals from Chinese regulators. As I mentioned before, the threshold, the 2 billion and the 1 billion or 300 million, the calculation of that amount has also been provided under the new regime, the new administrative measures. Basically, it includes securities, equities, technologies, IPs, and even debt financing. And under this new rule, that debt financing has first time become a factor when they calculate the aggregate investment amount. In the past, we all witnessed that many Chinese companies are chasing for the same project, and under the new rules, as well as under the old rule, as well as under the new rules, Chinese investors now required to report to the NDRC for the bidding projects before they start taking any substantive work, such as signing agreements or provide performance bonds, so on and so forth. So they need to get approvals from NDRC before they lock themselves in a contract. If you fail to do that, you will be censured and criticized by NDRC, and you will be ordered to rectify what you have done. It could be quite costly. If the project, if the proposal you submit to the NDRC fail to get approval or registered by NDRC, you can take administrative review actions either to seek administrative appeal review or take the matter to the court for judicial review. The timeline for the review, generally speaking, now has been shortened than before. Under the new rule, the NDRC must within 5 working days of the receive your application to notify you if they need additional information or supplementary document. Approval should generally be made within 20 working days. If NDRC does not have the resources to review or assess the feasibility of the project, they can engage external consultancy firms to conduct a review, but the review, this kind of review normally should be complete within 40 days. So the maximum time you can expect for approval now is about 70 working days. In the past, when Chinese companies prepare for conducting outbound investment, they will have a capped initial transaction costs, such as fees for financial advisors, for lawyers, accountants. Under new rules, there's no cap, but you're required to make separate application in order to get approved. We expect China's Foreign Exchange Authority, SAFE, will issue a directive in relation to that very soon. Another new features it's worthwhile to note is the validity of approval and registration. Approval from NDRC is not perpetual, and it is 1 year for ordinary projects or 2 years for construction projects. So if you cannot, if you cannot close the deal within 1 year for ordinary projects or 2 years for construction projects, you will be required to launch another application for the project. And also, if you want to change the equity structures, or if you want to increase the investment amount by 20% or more, you will be required to apply to NDRC for approval as well. This new regime is more transparent, but details always devil's always in the details. So we are still waiting for the implementation rules to be announced. So we have a better understandings and how this will work. But all the response from Chinese companies are quite positive. As China has now become the 3rd largest outbound countries in the world after the United States and Japan. And in the first quarter of China's outbound investment has reached about $20 billion US dollars based on MOFCOM's figures. So we still have to wait and see the details of the new rules, but overall the response and the feedbacks are very positive. Due to time constraints, that's all I have to say now. Hand the time over to Brett. Thank you.
Thanks, Ron. So yeah, obviously there's an interplay there in terms of if you're doing a deal with a Chinese buyer, where you're going to have to deal with both getting your NDRC approval, but if you're doing an investment or an acquisition into a country with merger control, you have to get an antitrust approval. There's timing issues. So if your antitrust approval is going to take longer than a year, it may in some situations, in some places, you're going to then have to get your NDRC approval again. So you've got to obviously, as an advisor or for your business, you've obviously got to take into account both sides approvals that are required to make the deal happen. Obviously, these are significant conditions precedent, and if there's a long time between getting these approvals, then there's all sorts of things that can happen at the time in terms of potential material adverse events or anything that could potentially scuttle the deal. Just quickly on industry trends, there's obviously been significant focus on Europe and UK by Chinese outbound activity, potentially seeing the undervalued assets in Europe, but also we think sort of focusing more on more stable markets. So there's a push from the Chinese government to move away from places like Africa to move into more certain financially secure projects that guarantee or don't necessarily yield as much, but are more stable in terms of their potential return. Obviously, there's some strategic objectives in terms of food, agriculture. In the last 9 months, agriculture deals are up by 4 billion. There's a focus on brands that can be resold back into China. Healthcare, life sciences, these are all sort of potential growth areas. In terms of Asia inbound activity, there's obviously a far broader range of significant activity. China still is a very significant target. There are various factors that have potentially reduced the focus or the interest in mainland China, and there is renewed interest in Southeast Asia in particular, and including Indonesia. Drivers for Asia inbound activity, Europe, US markets have been flat. They're looking for growth in Asia, obviously significant consumer, middle class market, significant activity, real estate, energy, leisure. It's worth noting still potential growth in activity in terms of private equity deals. Significant, very, very significant amounts of money have been raised for the purposes of investing into Asian businesses, and that a lot of that capital is still sitting there dormant, arguably because they haven't found the right projects, and that's why the cash is sitting there. But in due course, it is, there has to come a point where that money must be invested, and there's increasing pressure to put that money into projects. So there's obviously the quality issue on one side, but then there's the pressure to make that money perform on the other side. So we think there is another situation, another trend that we're going to see a lot more money flowing into the Asian markets as a result of this build-up. Notable deals, very recent deals, which are reflective of some of the trends in terms of inbound activity. Diageo have obviously have increased their stakehold in United Spirits, so very, very significant distillery business in India, tapping into the consumer market there. There are obviously still significant FDI hurdles doing business in India in many industries. Other indicators, this Temasek-Watson deal indicated sort of the Singaporean conglomerates being more active in terms of doing intra-Asia deals. The Australian consortium deal is a more indicator of the Australian market. It does tend to be quite focused on itself. The deals happening in and out of Australia are less significant. So China inbound status has been a drop compared to 2013, but as Ron mentioned, this is still a very significant market. Inbound activity is still very, very, very significant. There is a perception that, in particular for industries like manufacturing, the labour costs have become too much, and businesses are turning their attention to Southeast Asia in particular. There is the signs that existing investment by, for example, Japanese and Korean businesses in China, they might be looking to exit from those businesses, or they're certainly not looking to increase their activity due to political reasons. So that intra-Asia activity into China has dropped off, and that could be partly an indicator of some of that drop off there in terms of the percentage drop. the ability to do deals in China. There's still the merger control antitrust issues versus FDI. There's still the corruption analysis that needs to be done. But it's still a very, very significant market for inbound activity. A recent trend, and these have been in the pipeline for a couple of years, or for a few years now, is the new free trade zones in Shanghai and also nearby in Shanghai. At this point, these free trade zones are it's not really that clear about how they'll work. There has been laws that have been issued to try and explain how they'll work, but there's still a lot of detail to be released. Question whether the recent turmoil, protests in Hong Kong may push the Chinese government to accelerate the development of these free trade zones and to get on with deciding some of the details as to how the free trade zones will operate. In Shanghai, it's far more advanced than the Shanghai free trade zone, which is just across the border. So the Shanghai zone already does have a lot of companies that have been established, but there is still a lack of detail as to what some of these companies can do. The aim is to potentially have lower tax, but also have less FDI restrictions. We have seen a lot of inquiries from some of our bigger clients, big British insurers and others who have been looking at how to set up in the Shanghai Free Trade Zone to be ready to take advantage of the new rules once they're fully in place. So it is quite possible this will happen faster than we expect, faster than it's moved to date. Potential for RMB convertibility, but will that happen as a trend globally everywhere anyway? Yet to be seen. How does the free trade zone interact with the rest of China? There is still a lack of clarity on that. So if you operate an insurance business in the free trade zone, how can you sell your insurance products within China? Can you do that? There's quite a bit of lack of clarity about how the free trade zones really operate and how they are different to the rest of mainland China. A recent, very, very recent policy announcement in September. So they have been providing a bit more detail on some areas, so they've reduced the FDI restrictions in particular industries, shipping, automobile, civil aviation, and infrastructure development. So it's slowly becoming clearer. There is talk about law firms being able to set up in the free trade zone as well, and getting some accelerated benefits there. And there's been rumours of a few law firms looking at it, but at this stage, it's all very much speculation. Industry trends. Consumer goods was increasing over the course of this year, so that's still a very, very strong part of the inbound activity market. Healthcare, we still see as very, very significant. We've been working on a project for a client who's essentially providing healthcare services to aged care in an aged care type facility. A lot of interest from real estate developers in terms of these kinds of activities. Obviously, there's generally the hospital system is poor. There's obviously potential issues with people's health, with pollution. So it's going to be a big area where China does need foreign investment into the future in order for it to be able to cater for the demand. Indonesia inbound. A lot of media and talk about Indonesia's current status. If you've been following this market, it's obviously very, very interesting. I mean, as a starting point, Indonesia is obviously will be part of the new ASEAN economic community. So that is a new development which promises to be introduced in the next couple of years. The ASEAN economic community, they're talking about reducing trade barriers and reducing FDI barriers. So that potentially looks quite interesting and exciting if they can get those countries talking to each other and actually dropping down the barriers. Indonesia, in our view, represents more opportunity than the others in a very, very general sense. Obviously, the new government that's come in has very strong reputation. everyone you talk to in Indonesia, from the taxi driver to lawyers to business people, everyone's incredibly positive about the new leadership. And it's yet to be seen what will happen, but the signs are that there will be a crackdown on corruption. It's obviously a big problem in Indonesia, and they've got a long way to go. But the signs are that the new leadership is very, very clean, and they will go in there and genuinely tidy it up. The new leadership is also quite protectionist, so it's no signs that they'll immediately be dropping their FDI rules. But what should hopefully happen is that it should be improved rule of law. So at least we know what the FDI rules are, and we know we can work through them and around them and structure things in an appropriate way, knowing that the rules won't change suddenly, or won't be misinterpreted suddenly. So certainly from an inbound perspective, I think it represents good opportunity for foreign companies and similar opportunity for lawyers as possibly China did in sort of the 80s and early 90s, where there's an opportunity to sort of get involved in structuring deals to work through the FDI rules. So certainly we think it's a very, very, very positive time. It's obviously reflected in the law firms who have been all flooding down there to set up. But we continue to sort of focus on Indonesia through our Singapore office as a big part of our business strategy. Touched on before why UK outbound is of interest, less risky, more stable. Chinese government focus in particular on more stable projects. Why Hong Kong? We all know, we're all obviously in Hong Kong, we know what value and the benefits that Hong Kong has. There has been a lot more mainland companies setting up in Hong Kong over the last few years, not just companies using listing post status. There are companies who've got a lot more of their senior executives here who actually have genuine operations here. So question mark whether some of that may change with the recent turmoil. Obviously listing status, Daniel Land will talk more about the listing status in the next seminar. But obviously this is the key market for companies to come, get listed and use it as a launch pad for global M&A activity. Hong Kong listed companies obviously are well regarded, they can get finance more easily, and it's obviously a great platform for companies to launch off from. In terms of new companies law, and in Hong Kong we've introduced new companies law only in March, which was very, very overdue. It's been over 10 years in the pipeline. There are a few interesting features that are directly relevant to M&A related activity. One is that there's now amalgamation rules that allow a merger of intra-group companies, so you can merge your subsidiaries. There's certain requirements to do that. Obviously they need to be solvent. There has to be certain undertakings given. But there's sort of basically two scenarios. Vertical, where you end up with one subsidiary underneath the holdco. So in this scenario it's vertical, the subsidiaries merge with the holdco, you're left with this structure. And then horizontal, where you've just got two subsidiaries. So this does potentially offer some interesting opportunities in terms of internal restructuring, but also pre-deal, pre-M&A restructuring. And it just gives us a bit more flexibility in terms of how we do things in the future. And as I said before, it used to be a call process, so it rarely happened. So much more easier, streamlined process. Potential question marks over the tax treatment. Does stamp duty apply or not? There's been no IRD ruling in regards to this, but I just don't see logically how you could say that it should be subject to stamp duty. It just doesn't flow logically that it should be. But it's yet to be clearly decided, and people like Deloitte have issued papers saying it's up in the air and they're going to see if you want to do this. Things like free reduction of capital and share buyback. So again, gives you more options if you're using a Hong Kong holding company to structure a deal, or to use as your holding company or as your JV company. If you've got a Chinese JV partner and a foreign JV partner, the traditional thing is to always put an initial amount in as capital and put the rest of it, the investment in as loan, because loan could easily be repaid if the parties wanted and chose to repay it. There is now a streamlined, easier approach to get capital out. So you don't need to go to court to get your capital out. So there is considerations to be made. If if you are using a Hong Kong holding company as to how to put cash in. So there's some potential changes in the way we may do some deals, in particular JV deals. Financial assistance, one of the few places in the world that still has financial assistance, and it's always the one little tweak that Hong Kong lawyers can pull out of the bag if they're reviewing an English document's been approved by English lawyers and say, what do you think of financial assistance? And financial assistance is where essentially you're using finances of the target company to pay consideration for the deal. And it's a criminal offence in Hong Kong. It was expected it was going to be abolished with the new law. It's been abolished in the UK a few years ago, but they've kept it in. But what they've done is they've introduced an easier authorization procedure. So it still does need to be kept, you need to be aware of financial assistance when you're structuring any deal where there's a sale of Hong Kong shares. But the process to get around it is much easier. So you need to spot it and deal with it, and you shouldn't avoid it. Hong Kong, potential hub for other industry trends. General negotiation comments in terms of these trends. Merger control. Obviously, especially if you're doing a multi-jurisdictional deal, especially if you've got to take into account NDRC approval as well, you need to give early advice, you need to plan it, you need to have a consistent story that you're telling particular governments as to why you're doing this merger, explain the benefits of the merger properly. Obviously, the problematic merger situations have been where there has been a failure to communicate to the government and to the press and to the public as to why a particular deal should go through. Plan for remedies. So remedies are things like they say that you've got to dispose of a part of your business, or you can't acquire a part of this business that you're planning to target. So you should be able to plan for those sort of things as well. So the sooner you do the merger control planning, the smoother your deal will be. Often people focus on the commercial points, the pricing and those things, but actually merger control can be a big factor. And I guess in some respects, people who are based in Hong Kong don't think of it always because Hong Kong doesn't have any merger control regulation. Even when we get our new competition law, it doesn't include any merger control rules. So it's free to buy up your competitors without hesitation in Hong Kong. But typically, any competitor you have in Hong Kong may well have subsidiaries in another location, in which case you may trigger merger control rules in another place. So you want to get your merger control planning done early, and it can take a long time. I mean, if you've got to wait 12 months, the Glencore Strata deal, they had to wait 13 months to get South African merger control approval. 13 months to wait for approval can lead to all sorts of problems. Economic situation may change. The financial situation of either party may change. Parties may want to exit the deal in that time. So the earlier you plan as to how to deal with that issue in particular is a big issue. Local corrupt practices rules, as we talked about before, planning and dealing with those issues up front as quickly as possible is also a big sort of tip in terms of planning properly to do deals in the region. Obviously, the first issue you always look at when you're negotiating a deal is choice of law and choice of dispute resolution forum. Is there a trend towards Asian law as opposed to 20 years ago when every contract would have been under English law or New York law? There definitely is. There's definitely increasing numbers of mainland companies that are comfortable with Hong Kong and Singapore as a more neutral choice, or Hong Kong and Singapore courts. But at the same time, you do see situations where multinationals, banks, retailers who also say, well, actually we want to select local law because we want to, in a sense, show respect to the local jurisdiction, we want to show respect to the local courts, or local arbitration authority. We don't want to say, as a matter of assumption, oh, your courts are corrupt and therefore we would never dare have our contract to be resolved under your courts. So there's a potential sort of political public relations angle there for some big multinationals. Free trade zones. Is there going to be an emergence of, say, the Chinese free trade zones as potential forums for dispute resolution? If they have a different form of judiciary or a different form of law as opposed to mainland law, will that now be a potential choice, an alternative choice? And that's yet to be seen, but that could be a trend in the future. Overall deal flow. Obviously, at the moment, in the last 9 months, deals are going slower. Doesn't mean that deals are not happening, but people are taking their time. Buyers are being more cautious, and part of that is the corrupt practices issue. Part of it may be governmental issues of wanting to be seen to be, doing only the right deals. That gives opportunities for buyers to obviously insist on more warranties, to do better due diligence. That does lead to deal delay, and inevitably leads to deals falling over. Maybe other buyers step into the picture, or maybe the parties just get fed up with each other. So there is more deals, I think, falling over, but at the same time, I think the deal flow is still very strong. But it does represent, an important situation where you've got to get your initial documentation done properly, whether it's a term sheet, do the parties have exclusivity for a certain time period, do you have a very clear conditions precedent clause which enables, makes it very clear what needs to happen before closing. Those things do need to be negotiated more precisely in this kind of environment where the deals are being done at a slower pace. Do you need a MAC clause, a material adverse event type clause? So if something unpredictable, uncontrollable happens, especially given a very long delay on closing for one or both the parties to try and exit. Deals as a whole are being done on a far more sophisticated, cautious basis. So whether it's Asian sellers or Asian buyers, they're far more Western in their approach. They're less likely to say, we want to sell our business, but we want to do it on the back of a cigarette packet kind of deal very quickly. They were equally more aware of the documentation issues and the fact that they need good advisors. So there is, I think, a much greater degree of sophistication and caution, greater understanding of what due diligence is and why you need to provide it if you're a seller. In the past, there was a general reluctance, it still exists in some cases, but a general reluctance to provide a lot of information to a potential buyer. But there's a greater understanding as to why you need to do that. Corrupt practices DD still remains incredibly difficult because it involves really looking deep into a potential target. So it is a very sensitive area. Retention payments, deferred consideration, M&A insurance, all things that I think are becoming more prevalent in this sort of environment. So just in conclusion, lawyers' role in-house, private practice, deal delay, risk of deal failure, I think are sort of the biggest two factors here. So obviously need to plan better, try and accelerate timing, and try and actually have contingency plans if deals fall over or are delayed for longer periods. So we started late, so we've got 5 minutes or so. If anybody has any questions or comments.
Could you actually rely on the material adverse clause to get out of the deal?
Well, yeah, usually, usually you try and draft them in quite a precise way, so it can potentially be sort of acts of God, things that are very definedly outside of governmental control, but then sometimes they're drafted more broadly to extend to change of government policy. So it can be a very big get out of jail, get out of the deal type clause. So it is very important how you draft them.
So this question I think is moving on. In your experience, in terms of getting approvals and files for investments for Chinese companies, do you think it's an easier process for SMEs?
Well,
as compared to regular Chinese companies?
Well, if you try to get approval from Chinese government in the past, yes, because most SOEs are whatever they do outside of China, directed by Chinese government. mandate. I think one provision says that in the past you only need to get approvals from Chinese government, and then now you can all the county SOEs should be responsible for their own investment. So in that sense, it's easier. But all the SOE and the positions linked to the performance, like all jobs in China, and so maybe either in one sense, but people are certainly more cautious, SOEs in particular, before they conduct outbound investment.
So a follow-up question: as a foreign company who is potentially to be acquired by, for example, an SOE, would they seemingly make a better partner or acquirer because the process would be deemed to be smoother?
Well, this is very difficult to say. It depends who you're dealing with. We have experience when we work for some Chinese SOEs are very sophisticated and are very shrewd in doing business. Of course, they are better partner, but some Chinese companies are terrible. So it's all depend on who you deal with.
Well, I was asking more from a foreign company's perception.
Yes.
So, from perception-wise, would they think that is a
I
better
don't think
acquirer?
SOEs, generally speaking, because SOEs under Chinese government's control, particularly those are under SASIC. Private companies perhaps would make a better partner.
Yeah, the distinction between SOEs and POEs, in some ways, I think is sometimes not real, because you've got some POEs. They're investing and buying into areas that are being pushed by the Chinese government, so they've clearly got a strategic objective. They're not doing anything without talking to the Chinese government before they do it. They're remitting value or profits or payments back to the Chinese government potentially in a different way. And if they don't do what they're told, then they'll get sanctioned or in trouble, or their bosses will get arrested. So at what point are they different to an SOE if they've got all those factors in place? So I think it is a company by company analysis.
In the African resources space, there's been examples of that, where it's a private company, but all the things that you say are true.
Yeah. Like Sun Gold,
Yeah.
obviously done a lot in Africa. No one can quite work out who owns them, but it's clearly some Chinese government influence. And the other very interesting factors, people like Sailing Capital. These guys, they're a big foreign investment fund, a Hong Kong-based investment fund, a lot of sophisticated Western trained or Western educated advisors, but they're investing SOE money, they're co-investing with Viscos from Shanghai, they're collaborating with POEs, so it's all become a bit more less clear. There's a lot more collaboration going on at all levels, I think, with all types of Chinese enterprises. Any other questions? No? Thanks everyone.